Mr. Alexander.
My Lords, may I start with answering my Lord Kitchen's question, and also, actually, in doing so, refer to some more pages on customer journey, which will give a little bit of flesh to the answer if that's giving it. So Your Lordship asked whether the fact that the consumer has provided information matters and why, in the context of an experience that might be characterised as a website, as it were, moulding itself to the consumer in some way. Our submission is yes, it does matter, and it matters a considerable amount. And the reason is this: if one is considering the question of whether a activity is actively, in some real sense, targeted at a particular consumer, the extent to which the consumer, him or herself, is responsible for the appearance of the website, appearance of products on the website, and activities conducted by the undertaking is critical. What one is concerned with in this area of law is to differentiate between a situation where, on the one hand, it is really the consumer that is responsible for the goods in question being advertised, offered, delivered to the consumer. The consumer, as it were, going to the website with some intention of getting the products to the consumer, even if they know that the website is not intending to provide them specifically to that consumer. And on the other hand, the website itself seeking actively to develop a market to solicit that consumer. Of course, once a consumer has gone to a given site, there will be moments when the deal is consummated, just as they would be if a consumer went to Macy's for their Christmas shopping. I mean, Macy's in New York, and physically, and said, when a consumer from the UK, I'd like you to supply me with X or Y, and the store said, yes, that's fine. And the consumer then said, well, I'd actually like you to ship it to wherever it is, either me in England or whoever. In those circumstances, although the shop could reasonably be said to be attracting custom in Manhattan and possibly elsewhere, it would be very difficult to say that it was targeting the UK on the basis that once someone had gone there and supplied the shop with information relevant to the goods being sold in the country, that was to be regarded as having targeted that individual. You might say, following your Lordship's language, that, well, that's Macy's moulding itself to the desires of the consumer, saying, oh, we'll ship it anywhere. But even if that is a correct description, it doesn't follow that it is targeting the consumer in the UK. Can I just illustrate that briefly by reference to some of the pages that we've been looking at here? If you go in your electronic bundles to start at page 1250, you'll see some of the charming shirts with radio wear, which is quite that one. And you'll see that if you scroll down in those pages on the sort of journey, that the Cinch Boys long-sleeved shirt is there identified, again priced in dollars, with there a significant proportion of shipping expenses. True that it says that the item ships to the United Kingdom and you can get it by a given date and you can learn more. But that is in the context of a site where all of the articles appear, as you see if you scroll up through the other pages, as dollar items. And in all respectful submission, there's nothing they're other than the information that has been provided by the consumer, directly or indirectly, by the kind of automatic provision of that information as a default, that indicates that the UK is even involved or might be involved in that. And as I've said to my lords know, that's simply a default thing picking up on the IP address or whatever it is of the relevant person who is providing thereby information about them. You then go to the Add to the Cart page, which is 1252. Again, cart subtotal, item in dollars, and then you can proceed to the checkout. So again, there's nothing there that is particularly English. Indeed, there's nothing there that particularly suggests that the user there would even want necessarily to have these goods sent to the UK. Just come up on the screen because the consumer may be or have a computer that is indicating that the consumer is in the UK. Add to the cart, there's a subtotal, and then you proceed to the checkout on the next page. And then here, the consumer is providing Amazon with information about, in this case, himself. Here it's provided in the sign-in. You see that, Peter Elkin, Hogan Lovells. And it looks as though he has got an account, the password, which you see on the next page, 1254. And it's only after that that the information that's provided by the consumer is then reflected back at him in the Review Your Order page. So this is not a situation in which the website is moulding itself actively to those in the UK. What it is doing is taking information supplied by a person in the UK and saying essentially, yes, we can do that if you order us to do it. And that is why, in our respectful submission, it is not right just to look at this page in isolation, whether you regard it as an offer for sale or characterize it in any other legal terms. If you take this as a slice at the end, you are at risk of not looking at what the website is doing, but looking at what the consumer is doing to the website. And in our respectful submission, if one's looking for something more active on the part of the website, which we submit one should be, then you don't want to confine your attention to that kind of analysis.
If we were to come to the conclusion that some of the criticisms, at least some of the criticisms made of the judge's judgment by the Court of Appeal are sound, and we were also to come to the conclusion that some of the criticisms that you've made of the Court of Appeal are sound, what are we to do? Do we have to evaluate it for ourselves, or what happens then?
Goodness.
The answer will be yes, won't it? I mean, if there is error, if we were to conclude that both the judge and the Court of Appeal had gone plainly wrong, then would there be any option other than a re-evaluation by this court? Oh,
certainly, my lord, there would be, the re-evaluation would be required. I think, I was just thinking that what my lord was asking was by whom that re-evaluation should be undertaken. That's what I'd understood it to be, as to whether there should be an evaluation by this court for the first time, or whether it should be done by another.
Well, one might say that we've got the material in front of us, and you've taken us through the relevant parts of it, and we're not dealing here with large amounts of stock. So, is there any reason why we shouldn't evaluate it for us?
I can't at the moment think of one, but it's something that perhaps I might just ask my team about on this. No, I mean, in some senses with these cases, my lord's in as good a position as any to do these sorts of evaluations, in the sense that anyone is, our, I think, overriding submission on the underlying point is if your lordship concludes that both the approaches of the Court of Appeal and the trial judge could be improved upon, to use neutral language, you would then really need to think in our submission how much warrant there was for departing from the approach that the trial judge had taken. Because there are some situations where, even though it may be right to do a re-evaluation in a, as it were, super appellate court, evaluation done by the trial judge, which is criticised, but then so is the Court of Appeal, ought to be regarded as stickier, if I can put it like that, to appellate review. And the reason for that is that the court below will have looked at all of the evidence. And our submission on the Court of Appeal's approach is that that's really not what it was doing. What it was doing was saying, okay, well, some of this material is just to be set at naught. And to say, well, we're now going to redo it in that sense, we would respectfully submit is clearly your lordships can do that, but whether you should, in so doing, give particular respect to the approach taken by the primary finder of fact, that's a matter we suggest it would be appropriate. Does that sufficiently answer my Lord's questions?
Thank you.
Can we then move to the Blomquist point? Actually, just before moving to that, there are two more authorities, one of which I think neither side has mentioned, but I think it's right to mention. One of them I will try and pick up on Blomquist. One is the Walton case that arises in the Blomquist argument as well, which was a decision of Mr. Justice Arnold. And I'll come back to that in the context of targeting. And the other is a case of the Court of Justice called Pannon of earlier this year. I don't think either side has cited it, nor think that it takes matters further. It is an application of L'Oreal, and we've got copies of it, but we thought we should mention it so that you've got the full record of what the Court of Justice has said, so we can provide copies of it for you. I don't think we've got any submissions on it. I don't think the other side have got any submissions on it. It's a very special case on its facts concerning a particular.
Is it simply an application of L'Oreal? Is that
that's what it says essentially, and I can show that to you if you're interested in it. But I think that's the.
Is it in a bundle or a supplemental bundle?
It's not, I think, yet in either bundle, and I don't
if it could be sent in electronic form to register.
If we perhaps put it in the supplemental bundle overnight, if we're going overnight, then
thank you.
We can raise any points on it.
Then we can just pick it out of our files.
All right. So anyway, I think that concludes our points in relation to the first aspect, and I'll do a roundup right at the end. Blomquist. So the background of this point, of course, is that prior to the implementation of the restrictions by Amazon in early 2019, a small number of the BHPC goods were sold via Amazon.com to consumers based in the UK and the EU. And Lifestyle's case, essentially, which the judge rejected and the Court of Appeal upheld, was that regardless of the position with offers for sale or adverts for sale, those historical uses constituted use of the BHPC signs in the UK, and thus infringement, even if there had been no targeting at all. When I say even if there'd been no targeting, I mean, even if there'd been no prior targeting, and on the assumption that the sale itself was not ipso facto to be regarded as targeting. And that's really what the Blomqvist point addresses. So the judge, with all qualifications about the fact that it didn't really matter, for the reasons I've identified, he gave full consideration to the issue and made a number of findings of fact, including the fact that the relevant sales took place in the US, title to the goods and the risk of loss passed to the purchaser on delivery, the purchaser of the goods acted in a purely personal and private capacity and not in the course of trade. So this wasn't a situation in which the goods were sold in the UK with a view to being sold on. And the judge concluded that these sales did not constitute infringement because they took place in the US and they weren't use of the BHP signs in the UK and EU. And the Court of Appeal essentially overturned the judge's conclusion, interpreting Blomqvist by saying, in effect, that any time that a sale of goods bearing a mark is made through a foreign website to a consumer in the UK or EU, that automatically constitutes use of that mark in the course of the trade in the UK and the EU by the foreign trader, even if the sale takes place abroad, even if there was no targeting of the UK or EU in any respect. So even if, in those circumstances, the sale is, to follow my Lord Kitchen's question, entirely initiated by the purchaser in the UK, and albeit not resisted to the extent of refusing to supply on the part of the foreign website, that means that there's nonetheless to be regarded as use by the foreign undertaking in the UK. Now, my Lords, our submission is that that is actually quite a radical approach and a radical consequence, because what it would be there involved, if that interpretation were followed, is that the English court would catch acts undertaken by a foreign undertaking merely because the UK customer went to the trader's website and purchased goods for personal use, for private use, which are sent then to the UK. And as the judge recognised, and one of the reasons why he was resistant to this argument, that would create a long-arm jurisdiction, which was contrary to the territorial nature of trademark rights. And it's important to understand quite how long-arm the jurisdiction would be with reference to two aspects. First of all, the Blomqvist case wasn't concerning liability for trademark infringement. It was concerning whether or not the goods could be seized by customs. So within the territory, in some senses, Blomqvist was a sort of short-arm jurisdiction in respect of infringing goods, namely counterfeit goods. What the effect of Blomqvist has been essentially held to be is that it creates a long-arm jurisdiction with respect to acts of infringement taking place in the United Kingdom, giving the right of a proprietor in the United Kingdom to sue a foreign trader in respect of alleged infringement. And the reason for differentiating those two is because the way that Blomqvist developed, and I'll show my Lord the case shortly, was on the basis of the customs regulation. Now, what the purpose of the customs regulation is, just to be brief about it, is to ensure that customs authorities in the EU and the UK in particular are able to seize counterfeit goods, or goods that are asserted to be counterfeit, which have a particular definition in the regulation. The customs regulation is not about allocating rights for trademark infringement or rights with respect to who is to be regarded as liable. Now, as my Lords probably have picked up, it was quite a simple case in some respects. Mr. Blomqvist ordered goods from a Chinese online shop, goods sent by post from Hong Kong to Mr. Blomqvist in Denmark. Danish customs suspended the customs clearance on it on the basis that it was counterfeit, and it was a counterfeit. And Rolex said, well, we want this counterfeit destroyed, and Mr. Blomquist said, no, I want it delivered up to me, because you've got no right to hold it. So the first instance court granted Rolex's claim, and then the Danish Supreme Court referred to the case to the CJEU because it was uncertain whether the seller had infringed Danish copyright or trademark law. But the context of all of this was the application of, in particular, Article 2 of the Customs Regulation. And if I can just trespass on my Lord's patience a little bit, I just want to show you that, so that you can see the legal context in which this case arose. It's the bundle at page 244. And we don't need to go to a great deal of it, but I just want to draw your Lordship's attention to, first of all, the recitals and then the key operative provisions. So what this regulation is all about, as you get from the heading, is a regulation concerning customs actions against goods suspected of infringing certain intellectual property rights and measures to be taken against goods found to have infringed such rights. And so the whole structure of the recitals is about the importance of preventing counterfeit goods, pirated goods, and more generally goods infringing an intellectual property right which originate or come from third countries, preventing their release and circulation in the territory. And one sees that in recital 3 of the regulation. And that is reflected in the operative provisions, in particular Article 9, which you see on page 248, which permits the customs authorities to detain or suspend the release of goods that are suspected of infringing intellectual property rights. And those authorities are then required to inform the right holder and the declarant of the goods of their actions. Article 11 provides for a simplified procedure in relation to that. And then the question, of course, arises, well, what are counterfeit goods? And that brings one back to Article 2 of the regulation. That provides that counterfeit goods are goods including packaging, 245 of the bundle, bearing without authorization a trademark identical to a trademark, validly registered in respect of the same type of goods, or which cannot be distinguished in its essential aspects from such a trademark, and which thereby infringes the trademark holder's rights under community law. Now, one doesn't, in these kinds of articles, want to place too much weight on the precise language, but in our respectful submission, what this provision is getting at is saying, look, counterfeit goods are to be judged by the standards of trademark law in that context that are set out in other parts of community law. This is not a provision which purports to allocate liability for trademark infringement to any particular undertaking, which may or may not be liable for the ultimate act of infringement with respect to community law. What it's saying is that it's those kinds of goods which have those kinds of characteristics that are potentially subject to the customs regulation. And it's against that background that we turn to the case law, which again I think we can deal with fairly briefly until we get to Blomquist. The background to the case law is two cases which you have in your bundles starting at page 981, Montex and Phillips. It's Montex and Diesel, and then the next case is Phillips. Montex was a case where the Court of Justice ruled that the predecessor to the customs regulation introduced no new criteria for the purposes of ascertaining the existence of infringement of trademark law. And what that case was basically about, and I don't think we need to go to it in detail, because we've set out the key propositions in our written case, essentially asked the question of whether it was possible to seize goods in transit in a country where there was a valid trademark to a country where they could be lawfully marketed because there was no trademark in that country. So essentially there were goods going through Germany where there was a trademark to a country where there was no trademark. And the proprietor was concerned that there might be some diversion, so the question was whether that was possible. And essentially the Court of Justice said rather clearly that the argument was wrong. You couldn't simply seize goods that were in transit in a given territory where there was a trademark, simply on the basis that there might be some unquantifiable risk that they might be diverted. It wasn't a solid enough basis for doing that, because they were, in a sense, going lawfully to a country where they could properly be sold. Phillips, which is at 1033, and again, I don't think we need to go to the facts, to the case in detail for the present. The court was considering the application of the customs regulation to large consignments that were said to be in transit through the EU and had been placed under suspensive customs procedure. And the issue there was whether the goods that were imitations could be classed as counterfeit goods within the meaning of the customs regulation merely on the basis that they'd been brought into the customs territory under a suspensive procedure. And at page 1050 in your bundle, paragraph 78 of the case, the Court of Justice ruled that the goods may infringe the right in question and therefore be classified as counterfeit goods or pirated goods where it's proven that they're intended to be put on sale in the European Union, such proof being provided inter alia where it turns out that the goods have been sold to a customer in the European Union or offered for sale or advertised to customers in the European Union, or where it's apparent from documents or correspondence concerning the goods that their diversion to EU customers is envisaged. So what both of...
I beg your pardon, sir, I haven't found where you are.
Paragraph I'm sorry.
78, is it?
I think it's in paragraph 78.
Thank you.
It's the second of the indentations.
It's the second indentation in paragraph 78 of the Court of Justice's judgment.
Thank you.
And so both of those cases, and in a sense sensibly, were trying to draw a distinction between goods that were counterfeit goods or goods wrongly bearing trademarks that were going to the EU and goods that were going to a market where there was infringement and goods where there wasn't. And it was against that background of the customs regulation that Blomquist was decided. And I would invite my lords to turn up Blomquist just to see the nature of the decision and the nature, indeed, of the arguments that were developed in that case. That is at 967, and it's possible to pick it up at paragraph 30 of the... in fact, it's probably worth just going a little bit before that so that you have the context. Paragraph 25.
Page.
So it's 978.
Thank you.
So the first point made was that the Court of Justice noted that the customs regulation introduced no new criterion for the purposes of ascertaining the existence of an infringement of intellectual property rights, and that was a reference back to Montext. But by that, in our submission, what the Court of Justice was simply saying was that the customs regulation's understanding of what was counterfeit was the same as that would come from trademark law. Again, it wasn't seeking to allocate liability to any given undertaking for that. It was saying, look, this is the same thing as for trademark law. It then reformulated the question somewhat because the referring court was uncertain as to whether there needed to be essentially an act of targeting before there was infringement in the light of the developing case law in L'Oreal. And against that background, the Court of Justice's judgment doesn't have any information about the circumstances surrounding the sale of the watch, terms and conditions, and so on. It doesn't actually deal with the question of the potential conflict between a targeting and an analysis and the customs regulations at all, nor did it need to do so, because for the purposes of the Court of Justice's decision, what it was concerned with was in some senses, the rather narrow and question to which one might say there's a rather obvious answer, namely whether something which is an obvious counterfeit, which is in the possession of the customs authorities, can properly be seized. It doesn't, the case didn't need to consider in any detail the issue of who should be liable in relation to that.
But if the watch had been purchased by Mr. Blomqvist on a visit to Hong Kong, and had brought it back, and he brought it back in his suitcase, or for that matter on his wrist, and it had been seized by the customs, they wouldn't have been able to say it was counterfeit goods, would they? Because he wasn't bringing it into the country in the course of trade.
That is probably correct. They may not have been able to.
It's not good enough just to say sort of once counterfeit, always counterfeit, although that may well be how a man in the street might think of a fake Rolex watch. Because in this context, as they make clear in paragraph 26, it's all about whether there's been a user within the relevant jurisdiction in the course of trade.
Yes, and my lord is right up to a point. I'm slightly hesitant to say yes to the first part of my lord's question, because it's not completely clear to me that a customs authority would not have if, for example, they discovered it in a suitcase as someone was coming through customs, whether that would be impermissible. But I don't think that I need to deal with that.
I'm just testing your submission that all that mattered really was that this was a counterfeit watch, and we didn't have to look any further.
Yes. Well, our submission is certainly that that was the context in which the case was decided, because that was the issue that the court was really concerned about, was whether or not more was required in order for there to be a proper seizure. And one can quite understand that once goods are in the hands of a customs authority, to say, well, actually we need to establish more, in particular targeting of that watch to the
well, not targeting,
EU.
but apparently sale and delivery, I think, of
Yes.
that watch into a territory where the trademark was protected.
Yes, and that was the basis of the decision. Essentially, was that there was sale into the territory where the trademark was proposed to be. Well, there had been sale into the territory where the trademark was protected, and that was what gave the customs authority the power to sell it, but to seize it. But the alternative would have been extremely unpalatable, because what one then would have had was a situation where, even though the goods were properly regarded as counterfeits, they were within the possession of the relevant Danish customs authority. The customs authority would have to give them back to the purchaser of the goods, even though they were fake goods.
Well, but now it's your example of an infringing article sold in a shop in New York, where the buyer goes to New York and brings it back on the Queen Mary with him in his suitcase. It couldn't be seized just because it was a fake.
Yes, I accept that. I mean, there may be issues in relation to they were real counterfeits or parallel imports, but leave that point aside just for the time being.
I mean, the trouble is when we use fake, we use it as meaning something more or different from infringing a trademark.
Yes, or possibly less and different from infringing a trademark, but in any event different from infringing a trademark. Our point, however, on this is that if one looks at the analysis that the Court of Justice actually undertook with respect to this particular issue, which is actually very brief in paragraphs 30 to 34, as my lords will have picked up on, what they don't really grapple with is the extent to which there is a conflict between the approach to targeting taken with respect to other acts of potential infringement that take place within this country, and the approach relating to sale. Because if one regards this short analysis as being absolutely comprehensive across the board, the impact of it would be to actually completely undermine the approach of analysis in L'Oreal. Because what one would essentially be saying is, well, actually forget completely, for every case, a situation where a nuanced analysis as to whether or not there has been targeting, the fact that a sale has been made to a customer in the United Kingdom is the and the only factor that matters for the purposes of this analysis.
Is that necessarily right? Because in the case of offers and exposures for sale which are targeted, that goes a good deal broader, because there may be an infringing activity there which doesn't result in a sale or a supply or a distribution. We're only concerned in this particular case here with the actual distribution itself.
Yes, my lord is absolutely right, but there would be a lack of equivalence both ways. So essentially what the law would be on this hypothesis, if one were to interpret it in this way, is that any time there was an act of sale to someone in, and there is some uncertainty about in the EU, there would automatically be infringement on the part of the foreign trader, even if that had been sought by the person in the EU. Now, we respectfully submit that the Court of Justice was not intending to go that far, and we referred to paragraph 34, where there is a distinction that they seek to draw, where it said it's common ground in the case of the main proceedings, the goods in issue were the subject of a sale to consumer in the EU, such a situation not being therefore in any event comparable to that of goods on offer in an online marketplace, nor that of goods brought into the customs territory of the European Union under a suspensive procedure. So what they are saying here is there are two lines of authority, one of which is the L'Oreal line, and the other is the Montex Phillips line. And this is a separate situation. But there was no analysis of the extent to which this approach, if applied across the board to an online marketplace, would mean that every time an online marketplace sold a product to a customer in this case in the EU, there was automatically use of the sign in relation to those goods within the EU, regardless of what had happened before. And indeed, our submission is that they were distinguishing this situation from one of the online marketplace. Now, what's said against me on that is, well, they were distinguishing a situation relating to offers for sale rather than sales by the online marketplace. But in our submission, that's a too narrow approach to that paragraph. What the Court of Justice was recognizing was, here we've got a situation that we need to deal with in relation to the customs regulation, and we will deal with it in this way. We are leaving open the issues of how one ought to treat the question for the purposes of online marketplaces. And in our submission, this issue of how you resolve the tension between a non-targeted sale that has been sought by the consumer entirely, has simply not been subject of really either detailed analysis or any analysis. The Blomqvist case was one that was decided without even, I think, an opinion of an Advocate General. There was very limited analysis of the impact and the interrelationship between the two regimes. And so this is not a situation in which we, in our respectful submission, say that the Court of Justice had made a ruling that was applicable across the board for all kinds of sales, all kinds of marketplaces which would be applicable. And one can tell that in our submission by the fact that when the court came to make its determination in paragraph 35 reflected in the dispositif, it said, in the light of the foregoing, the answers to the questions, customs regulation must be interpreted as meaning that the holder of an IP right over goods enjoys the protection afforded to that holder by the regulation at the time when the goods enter the territory of the member state, merely by virtue of the acquisition of those goods. It is not necessary, in addition, for the goods in issue to have been subject prior to that sale of an offer for sale or advertising targeting consumers of that state. And that is said in the context of the customs regulation. Now, the Court of Appeal's approach was to say, well, the approach of the customs regulation and the approach of trademark law have got to be, in a sense, completely assimilated together, so that if you are within one, then you're within the other regime. We respectfully differ on that. The customs regime is there, directed at counterfeit goods. The trademarks regime is directed at acts of infringement that where liability is allocated to given undertakings in respect of acts which they may undertake in the United Kingdom. So in our submission, this is an issue that your lordships are entitled to look at for yourselves. It's one that before the trial there was a suggestion might be referred to the Court of Justice, and for various procedural reasons was not. It was right at the end of the Brexit period. But this is a situation where, as we've set out in our written case, it's not a question of departure from EU law. What your lordships, in my respectful submission, need to grapple with is whether or not this approach could reasonably be taken to be applicable across the board or applicable in the particular context of the customs regulation in which those observations were made, and having regard to the focus of the customs regulation on the goods themselves rather than any act of infringement by any undertaking. So in our submission, the point in issue is, in some senses, a fundamental one in the analysis overall, because if your lordships conclude that the appropriate course for other acts of alleged use of a mark involves a multifactorial test looking at the whole context, then our submission is that it would be anomalous to then conclude that an act of sale, which on at least one hypothesis may be completely sought by an individual in the EU with no targeting, was invariably to be regarded as an act of infringement by a foreign website. And we respectfully submit that the instinct of the judge, which your lordships will have seen, which is to say, well, if that's right, this really would drive a very big wedge through the idea of territoriality of trademarks, because someone could, without, in some senses, knowledge of what they were doing beyond the fact that they were fulfilling an order at the request of a customer in the UK, be liable for infringement. And the context in which that kind of question arises is one in which one has some websites which have large number of goods on them. It's not one that would be applicable only to single articles or single trademarks. And in our respectful submission, that is not an appropriate approach. The approach should be, for the question of the trademarks jurisdiction, one that involves the L'Oreal approach in its entirety. And it's no good to say, oh, well, we'll simply regard sale as being something that constitutes targeting. It is, in our submission, not a sensible approach to say, well, we'll just override the whole law relating to that, notwithstanding its territoriality, once there's been a contract concluded. And there are...
Is the Blomkist case, on your analysis, problematic beyond online sales.
Oh, yes. I mean,
I was just going to suggest that on the face of it, it would seem not to be restricted in that respect, and therefore one thinks of scenarios where somebody goes to the United States and purchases and brings goods back into the UK, and the sale suddenly becomes problematic.
Subject to my Lord Briggs's point as to whether there is an act of infringement.
Yes.
I think
If something is brought in by a private individual.
I think I read the facts of Blomqvist as meaning that the manufacturer or the supplier delivered the goods into was it the Netherlands?
Yes.
Not Denmark. I'm so sorry. Yes, it was the supplier who. I mean, the contract was for the sale and delivery into Denmark
absolutely.
of the goods,
Yeah.
so that no one would doubt that the act of bringing it into Denmark was that of the supplier, done in the course of trade.
Yes.
But I was wondering, what if you go to Bloomingdale's and buy some rather cumbersome piece of goods, and they say, well, we'll deliver it to your house in Kensington.
Well, indeed.
Is there any authority on whether a contract of that kind, made in New York, but for performance in the UK by the delivery of the goods, which in the UK would be infringing goods, is an infringement of trademark?
We haven't been able to find any such authority. What has been referred to by the other side is two cases, Cartier and Walton, which I mentioned. Cartier does mention Blomqvist, but in passing, because it's not really about that. It's a blocking injunctions case. And Walton, actually, if anything, is slightly against that point, because that's a case which is in the bundles. I don't think we need to go to it, where Mr. Justice Arnold was looking at the issue of use for the purposes of supporting continued registration of a trademark, which is, I accept, slightly different, because one has to look at the extent of use to a degree. But what was not suggested there was that the mere act of sale would be one that was...
Sale into the UK?
Yes, that more of a single article. And one's got to be a little bit careful about that decision, because it wasn't really focusing on the issue that we're concerned with here, and one can't take too much from it. But I don't think that there is any authority, in a sense, other than Blomqvist, and obviously what the Court of Appeal has said in this case, that puts the matter so starkly. The texts, which are again referred to, just have a throwaway line with no rationale. I mean, it's in a sense less analytic even than paragraphs 24 to 30 of Blomqvist in relation to the potentially expansive nature of the approach.
In principle, what's the objection in principle to extending trademark protection against, if you like, someone who, in the course of his trade, brings goods for delivery to a resident within the jurisdiction? Merely, what's the objection in principle, founded on the proposition that the contract for the purchase of the goods was made offshore?
Well, my Lord is right to ask the question as to whether the legal aspects of the contract, where it is made, what the governing law is, and so forth, how those relate to the question of trademark infringement. Because you might say, well, actually, they're orthogonal to one another. Yeah? However, what that requires, what the analysis requires in our submission, is that one focuses on this question of whether or not the goods are actually being brought into the UK by the customer, or whether they are being, I don't like this word, but some will, pushed out to the UK by the relevant website, with the ultimate destination of that activity being a contract that is made for sale of those goods, because the contract is the sort of end of the process. The issue of principle that is the objection is that if one accepts that it is right because of the territorial considerations to look at a whole set of factors to determine whether or not there is to be regarded as use within a jurisdiction. Not sale of a product within a jurisdiction, but use of a trademark within a jurisdiction. It should equally be right to look at that with respect to the act of sale as it is to any other act that is alleged to infringe.
Well, Mr. Alexander, can that be right as a proposition? Supposing I ring up, if I ring up Bloomingdale's from London and I say, are you able to sell and supply to me in London X goods under X trademark for X price, or what is the price? Would that not be a sale and supply into the jurisdiction of the goods and amount to an infringement?
No. In our submission, one has to distinguish between the concept of the passing of property or the delivery of goods or the contractual and property aspects, and the question of whether there is use by the undertaking in question in relation to the United Kingdom. It may be that the goods are infringing goods. It doesn't follow from that there is use by the vendor in question of the trademark in the United Kingdom. And my lords may say, well, that's a...
But how, if there is no use of the trademark in Nottingham, can they be infringing goods?
Well, this is the point that we make, which is the kind of or insufficiently analysed point in Blomquist, which is that if you focus on the customs regulation, you don't really need to analyse that point because you look to see whether or not there is an infringement, whether the goods are in fact counterfeit by reference to the standards of the relevant regulation. The focus is not on whether or not any given undertaking is or should be liable for infringement. But otherwise, what one has is essentially the effect of the customs regulation is to determine liability for infringement on the part of a foreign vendor by a sidewind, the sidewind being that because you interpret the customs regulation in that particular because you interpret the customs regulation in that particular way, you're then forced by your approach to it, as Blomquist imports, to then treat the trademarks regime in the same way. And we respectfully submit that that is not what the customs regulation contemplated. Customs regulation is about the goods that are in the jurisdiction. It's not about having suddenly created a new liability for sale of those goods.
So, as I understand your response to my Lord Kitchen, with his example of the telephone sale from the United States with delivery into the UK, you would say that can't be what Blomquist actually lays down because that is far too wide. So it must be restricted in some way.
That's exactly right, and indeed it follows. That's an answer of the same genus to the answer I gave my lord on the different point, namely how broad would this go? If I'm wrong, then obviously my Lord Kitchen is right in relation to the telephone example, because there would be in a sense no answer to that point on that hypothesis. But that is one of the reasons why we respectfully submit that the approach in Blomquist should not be interpreted as requiring this overriding effect with respect to sales because of its potential breadth.
But your submission seems to have the consequence that whereas if I bought a fake Rolex watch in the Chapel Market, the seller would quite plainly be infringing Rolex's trademark. But if, on the other hand, I simply saw an advertisement in the Chapel Market, well, if I simply phoned up the supplier and said, please supply it to me to my residential address 1 street away from the Chapel Market, there would be no infringement at all.
When you say the supplier, you mean the supplier out of the jurisdiction?
Yeah. If somebody makes infringing Rolexes in Hong Kong is liable if he comes to the UK to sell them, but perfectly free to sell them offshore and deliver them to the UK with exactly the same commercial result for the buyer, it doesn't seem a very principled distinction.
Well, it is a principled distinction if one believes in territoriality of trademark rights. Well, if one doesn't...
With full belief in that, because what I'm looking for is what happens in the Chapel Market or the street next door.
Indeed. And my lord is of course right that in some senses it would be quite desirable if there was a sort of universal regime, a sort of international regime in respect of this, so that it didn't matter whether you were in Chapel Market or Nanjing for this situation. But it's not quite as simple as that, because as your lordship knows, there may be issues where someone has a legitimate right to sell. It's not really a fake situation. It may be a no trademark in a given country and a trademark in another country. But the law does differentiate in this country between acts that are done in the United Kingdom and acts that are not done in the United Kingdom. That's the starting point of trademark law. And so it's not an unprincipled approach to say, well...
According to Blomquist, it's the sale into the EU which is the relevant act which infringes the intellectual property rights and which thereby renders the goods counterfeit.
Indeed. But I think answering your lordship's question, is there a principled basis for distinction between the two Chapel Market situations? Yeah. Yes, there is. It may not be an ideal approach, but it is also a basis that actually then harmonizes the approach to looking at whether there is use in the United Kingdom between all of the potential acts of infringement, whether they be sale, offer for sale, and so forth, which the alternative doesn't, my lord.
Mr. Alexander, there's a distinction between a multifactorial assessment of whether or not a foreign website is targeting the UK on the one hand, and on the other hand, whether or not a single sale and supply is or is not an infringement, because that is assuming the mark is protected in the jurisdiction and an identical mark is applied to the goods for which protection has been secured in the jurisdiction. That is not a multifactorial assessment. That's a yes or a no question and answer, isn't it? It only admits of one answer either way. It's not a general assessment of similarity of goods or similarity of marks, or is there targeting? Is there a distribution in the course of trade or not?
Well, my lord, you looked at in that way, of course, it's in essentially giving the answer in the question, because if it's right that sale involves infringement, or sale involves use in the United Kingdom, then of course sale involves use in the United Kingdom. There's no debate about that. The question that I'm inviting my lords to consider is whether that should be the right approach that one should take across the board in circumstances where that approach is not taken in relation to offers for sale and advertisements. And our submission is that...
when they're abroad.
Indeed.
The distribution in the example I'm putting to you is in the jurisdiction. Because the foreign supplier is supplying that good into the jurisdiction under the mark for supply to the domestic customer.
Well, again, my lord needs to be a little bit careful about what one means by supply into the jurisdiction, because this is a situation on the facts of the case where the property in the goods passed in the United States, so outside the jurisdiction, pursuant to a foreign law contract, and when the person bringing it into the jurisdiction was doing that, they were acting essentially as a private individual. That's the whole point. So what one can't do is to simply say, well, because someone has... the situation might be different in circumstances where, let's say, property did pass in the United Kingdom, or the website came to the United Kingdom to actively deliver the goods to someone in Chapel Market.
I was thinking more of a case where there's a telephone call between...
I understand, but the telephone call example is actually a good example, because let's suppose that the response to that call is, yes, of course, But these are our standard terms. You take delivery, whatever it is, FOB in New York, or we can arrange with a carrier to have them sent to you. My point is that the commercial acts in question all took place outside the jurisdiction, and the bringing in was bringing in at the suit of the customer, or on behalf of the customer. So it's that situation that my lords need to consider as to whether Blomqvist was dealing with that, and I do apologise if I haven't really focused on that, but it's what the judge focused on, and rightly so in our submission. If one takes the contrary approach, that doesn't matter at all. Always, wherever property passes, wherever contract is made, pursuant to whatever law, there's always a use in the United Kingdom on the basis of a sale in the United Kingdom. That, in our respectful submission, is going very, very far. So that's the core of our submission here, is that you do not need to go that far for Blomqvist. There isn't a principal basis for going that far, that the judge's inclination not to go that far was reasonable and well-founded in the context of international commerce. That a rule that says, no, you need to look at all of the circumstances is actually a fair rule, because in cases where there was genuine targeting of the UK, then you'd pick up the infringement and you'd say, yes, we can sue abroad. So it's not as if we're letting someone off the hook and saying, oh, well, there's no possibility of liability. What it is doing is saying, yes, there is liability, but it is limited to these situations. So that's the core of our submission in relation to Blomqvist. I've made some points in the written argument, and I'm sorry for going on a little longer.
Well, you've been asked questions, but I'm going to point out to you that you're now into injury time,
yes.
And you'll be using up your reply time.
Yes, I understand that. We've made points in relation to the European law. I don't think I need to develop that any further. This is not a case for departure from Blomqvist. This is a case for interpretation of the kind that we've articulated. So in our respectful submission, for the two reasons, one, the multifactorial analysis is correct and the judge's approach is to be preferred, and two, that Blomqvist's proper interpretation should not undermine that in the case of a contract of a kind of this nature. In our respectful submission, the appeal should be allowed. Unless I can assist my lords further.
Thank you very much, Mr. Alexander. Mr. Edenborough.
My lords, I was going to, if I may, make my submissions in three parts. The first of which is to make some preliminary points so as to lay the foundations upon which all my further submissions are laid. The reason for covering a number of those foundations is that they will cover certain general points, and it will allow me then to refer back when I make the particular points. The second is to deal with the ground one, and then the third is to deal with ground two, the Blomqvist point. But given the way in which the timing has fallen, I was wondering whether I may make my general points first and then deal with Blomqvist, because that's the shorter of the two grounds, and I should be able to finish both of those today, and then that leaves me the 2 hours tomorrow to deal with the longer ground in one unified whole.
Yes.
My lords, thank you. So, as you can imagine, my first point is really that we say that the Court of Appeal got it right for the right reasons, and therefore this appeal ought to be dismissed. But the way in which these arguments can be looked at in the round is by looking at a number of foundation points. The first of which is that this case involves, we say, a fairly simple issue of trademark infringement pursuant to Article 9.2a of the relevant regulation. And with respect to such infringement, there are 6 conditions that have been laid out by the Court of Appeal into Flora, and those conditions are, first, use within the jurisdiction, 2, use in the course of trade, 3, without consent, 4 is there has to be an identical sign, 5, there has to be identical goods, and 6, there has to be damage that flows from the foregoing.
And we're concerned with 1 and 2.
Yes, my lords, exactly. And in particular, with little Roman 1, which is use within the jurisdiction, there are 2 points within that, namely use and within the jurisdiction. And so if one moves to consider the issue of use, the point here is that there are different acts that count as use for the purposes of trademark infringement. And here it is useful to go to the regulation itself, if I may, which may be found starting at page 252. And infringement is pursuant to Article 9, which is on 253. And so 9(2) is without prejudice to the rights of the proprietor acquired before the filing date or the priority date of the EU trademark. The proprietor of that EU trademark shall be entitled to prevent all third parties not having his consent from using in the course of trade in relation to goods or services any sign where, and then it gives various details. But the point being is that the uses that are prohibited are given in a non-exhaustive way within paragraph 3, which is on the next page, 254. Now, the first thing to notice here is that this is a non-exhaustive list of those things that amount to acts which fall within the ambit of use that can be prohibited. And we're particularly concerned with 3B, offering the goods, and also 3E, advertising. But what you will notice is, for example, that an actual sale is not mentioned as such. Now, the trial judge rightly put this to me, and there are 2 answers to that. The first of which is, that's an example which, using terminology, is it goes without saying that a sale of the relevant goods or the provision of services under the relevant mark would amount to a prohibited act. But another way of looking at it is that it falls within Article 9(3)(b), putting them on the market, because a sale would put the goods on the market. But what I also want to draw from this is that this is clearly not...
Would a sale put it on the market, or would it take it off the market? I mean, you put it on the market and sell it.
In that sense, my lord, putting on the market means that you're transferring the title from person A to person B.
Is that what putting on the market means?
In this context, my lord, but I don't need to get down to that point, because however you want to look at it is that a sale would somehow be covered by the prohibited acts. And if you don't wish to put it under the category of putting on the market, it then falls into the unspecified types of acts that would be prohibited. Also, you need to look at the fact and bear in mind that each of these acts amounts to a separate potential instance of infringement. So therefore, you could have an offering of the goods, and you could have the advertisement of the goods, or you could have, under 3C, an importation of the goods. So, with respect to any particular set of goods or services, there may be a number of distinct acts that amount to separate and distinct instances of infringement, and that in any particular commercial transaction or journey of the goods, there may be a number of different infringing acts.
But going back to sale, that would have to be in the jurisdiction.
Yes, I was going to deal with that, my next point, my lord. But yes, without a doubt. It's not said expressly here, but my learned friend mentioned that within Section 9 of the Trademarks Act, which is in essence in a similar language, it does include those words within the UK. And it's always been taken that a similar restriction applies to Article 9 of the EU trademark regulation.
Can you just help me? Subparagraph C in paragraph 3 is importing or exporting the goods under the sign.
Yes.
Does that have some special meaning, requiring the sign to be, as it were, on the outside of the package?
No, my lord. What it means, it's more general in the sense that, say, if we take goods, for example, the goods could be marked, the actual goods themselves could be marked.
Yes.
They could be stamped, for example, on an engine block or something, or they could be packaged with the mark on the packaging. So it's not limited to just the packaging, for example. It could also be more in the sense that the goods and their packaging may not have an actual mark on them, but they are imported under the sign, namely, for example, if all of the importation documentation refers to 6,000 Rolex watches, for example, that are not actually stamped either on their boxes or the Rolex themselves.
So if the sign is on the goods, then it falls within C.
Yes.
But C is under the sign is intended to go wider.
Yes.
Right.
But it doesn't arise in this case.
No, but I'm thinking of Blomqvist.
Yes, I see where you're going on that. But it's necessary to say that the Court of Appeal expressly decided not to decide anything on importation.
Right.
Now, I've just said that any particular commercial transaction may have a number of different events that amount to distinct acts of infringement. Another point that's important to make is that you only need a single act that falls within any one of these prohibited uses. So a single sale, or for example, a single offering of the goods, would amount to infringement. There's no de minimis qualification here. Of course, if there were only one sale or one offering for sale, then damages would be far lower and there may be other effects on other remedies. Now, then picking up on the point that's just been made to me by Lord Hamlin with respect to the within the jurisdiction point, that's critically important because these acts must occur within the jurisdiction. There must be something that tethers them to the jurisdiction. There is absolutely no long-arm jurisdiction at all. In any circumstances, there must be something that ties it to the local jurisdiction, be it the UK for the Trademarks Act or the EU for the EU regulation. And that's absolutely central. And we say, though, that when you look at the range of the different acts, the way in which you ascertain whether or not something is tethered to the jurisdiction can vary, the way in which you ascertain that tethering. So picking up on the point that my Lord Kitchen made, is that if there were a sale within the jurisdiction, you really don't need to do any more consideration other than to ascertain whether or not there was a sale. It's a concrete event. There's a yes-no question, basically. But if you're looking at something that is superficially more removed from the jurisdiction, in order to ascertain whether or not it is properly tied to the jurisdiction, you might need to do a fuller, more in-the-round ascertain of what are the relevant facts. And this is where we get into the issue of targeting and the jurisprudence based upon that. And you'll have seen, of course, from the various cases, Merck, Argos, L'Oreal, Panmar, and what have you, then you have to have a consideration of various different factors to see whether or not it is proper to say that the act, the allegedly infringing act, namely a offering for sale, is properly considered to be tethered within the jurisdiction. Now, the next point that I wish to make is that you need to look at these things through the eyes of the average consumer. How are these things perceived by the average consumer? Now, the average consumer turns up a lot in trademark law. So, for example, the average consumer turns up when you are considering whether or not a mark is distinctive, or whether or not there exists a likelihood of confusion. And the average consumer is a construct in the sense that they are deemed to be reasonably observant, reasonably well informed, and circumspect. So they are a construct. They don't actually represent any particular single natural person. But they're not a mathematical average of everybody out there. Rather, it is a construct that is designed to eliminate extremes. And for your note, you can see all that in paragraph 54 of the Court of Appeal, which in essence just says that. Now, the next thing is that you have to judge these things objectively. And the easiest way of finding that is, it's in actually a case that it's not quoted within our authorities bundle, but it is within the judgment at first instance. And it's at paragraph 114, which is on page 207. And the case is A v. B, which was a case about importation and actually dealt with 750 kilograms of industrial-sized ball bearings. They're of the size of cannonballs as opposed to the small ball bearings you might get in a bicycle, for example. And because this was an Article 267 reference, it was dealing with the trademark directive, and in particular whether or not there was an infringement, and that's Article 5 in the directive. So when you go to the quote in paragraph 114, it says at paragraph 22 within the quote, first, it must be observed that the question whether the conditions laid down in Article 5.1 of the directive are satisfied must be determined solely on the basis of objective factors. So Article 5.1 of the directive is in materially the same terms as Article 9 of the regulation, just that one relates to those the trademark laws that have been implemented within each national jurisdiction. The regulation, of course, is pan-EU. The important point to take here is that you're looking at objective factors, and that's front and foremost of the way in which you need to look at things. Then, what we say is that the role of the average consumer is front and center of the way in which you look at these things, and support for that proposition comes from, for example, Merck, but I was going to deal with this in more detail tomorrow, so if I might just give you the reference now. It's Merck at 169, where you're looking at the issue of targeting, and it says it should be ascertained objectively from the perspective of the average consumer. But as I said, I'll deal with that in more detail tomorrow when I look at the ground one point.
Sorry, what was the reference?
Sorry, it's Merck, my lord, paragraph 169, which is on page 527.
Thank you.
Thank you.
And then next, you are allowed to look at all the relevant circumstances. And again, there's a point there from Merck, which is paragraph 170. It's on the same page, my lord. And again, I'll deal with that in a bit more detail tomorrow when I deal with the targeting point.
I think it says must rather than can, doesn't it?
My lord, yes, sorry. And then the next point, this is with respect to how you look at the various cases on targeting, because some of the cases are infringement cases and some of the cases are revocation for non-use cases. And you will have seen from the Court of Appeal judgment in this case, it's paragraph 52 for your note, page 160, that you are allowed to cross-fertilise. And the reason you're allowed to cross-fertilise is because infringement cases and revocation cases have something in common. And that is as follows. When you're looking at infringement cases, you need to look at whether or not the use infringes. And in revocation cases, you need to see whether or not the use is genuine. So in both cases, you have to look at the use, and that's the commonality between those two cases. But you note from that analysis that there is a difference between them. Obviously, when you're looking at infringement cases, you're looking at certain infringement aspects that are contained within Article 9. And when you're looking at genuine use cases, you need to see whether or not the case law on genuineness applies. And the reason why that is relevant is because you mustn't muddle up the various factors. You mustn't cross-fertilise inappropriately the genuineness of the use when you're trying to the genuineness of the act when you're trying to ascertain particular points about the use. I'll explain that more when I come to look at Walton, for example, which is a non-use case. And it's actually the same in BDO as, BDO is slightly different. So I'll leave that to one side. So those are the general points that I wanted to make. And then I thought I'd go on to Blomquist, because I can pretty much, I hope, finish that this afternoon. And it's useful if we actually start with the customs regulation, because that is where my learned friend started. And in so doing, I might be able to answer some of the questions that were put to him. So you'll see the customs regulation is at page 244. This is the new customs regulation, but it doesn't actually matter for our purposes because the material parts are the same as the old customs regulation. And the reason I draw that distinction is because Montex was concerned with the old regulation. But starting where my learned friend did, this is a regulation concerning custom action against goods suspected of infringing certain IP rights and the measures to be taken against goods found to have infringed such rights. So it is a sine qua non here that you must have infringement. To make good that point, if you look at Article 2, in particular 2.1a, counterfeit goods, including packaging, bearing without authorization a trademark, identical to the trademark, validly registered in respect of the same types of goods. So basically you have identical mark and identical goods here, which thereby infringes the trademark holder's rights under community law. You must have an infringement. No infringement, customs regulation doesn't bite. Once you do have an infringement, that then gives the customs people the authority to do certain things, seize the goods or potentially destroy them. Those powers are contained in the later parts of the regulation. And if you go to Article 10, which is on page 248, the law enforced in the member state within the territory of which the goods are placed in one of the situations referred to in Article 1.1 shall apply when deciding whether an intellectual property right has been infringed under national law. So that drives home the point that you need infringement of the right. Now, to pick up a point that was raised by my Lord Briggs with respect to buying a counterfeit Rolex abroad and then bringing it back either on one's wrist or within one's luggage, there is provision within Article 3.2 of the Customs Regulation 246, which says, where a traveller's personal baggage contains goods of a non-commercial nature within the limits of the duty-free allowance, so there's two qualifications there, and there are no material indications to suggest the goods are part of commercial traffic, that reiterates the first point, member states shall consider such goods to be outside the scope of this regulation. So those goods can't be seized. But there's a more fundamental point, and that is, if the person bringing the watch back on their wrist is not acting in the course of trade, then that act is not an infringement, because the allegedly infringing sign has to be used on goods in the course of trade. And if there is no course of trade, you fail to satisfy all of the necessary conditions in order to get infringement off the ground. Now, with that by way of introduction to the customs regulation, if we go to Blomquist itself, and in particular, we start at page 976, paragraph 21. Literally halfway through this paragraph, it says, since it is established that Mr. Blomquist bought his watch for personal use and did not breach Danish law on copyright and trademarks, the question arises for the referring court whether the seller infringed copyright or trademark law in Denmark. So that, in my submission, is a clear finding that there was no infringement by Mr. Blomquist because he was acting in the course of his personal use, i.e. he was not acting in the course of trade, and so therefore the necessary requirement for trademark infringement to arise was not fulfilled. Now, my learned friend has taken you to Montext, and it's in paragraph 40 of Montext.
Paragraph 21 is just posing the question, isn't it, in relation to...
Yes, but I mean that fact is what is carries through. I've just highlighted it because it says it most conveniently in the short form there. Montext in paragraph 40, which is on page 1012, that's where you get the statement that nothing in the old customs regulation introduces a new criterion for the purposes of ascertaining the existence of an infringement of trademark law or to determine whether there is an issue, whether there is a use of the mark liable to be prohibited because it infringes that law. So the point there is that you need to look at the trademark law in order to see whether there's an infringement, in order to see whether you can then invoke the customs regulation.
Sorry, can you give me that reference again?
Yeah. Yes, my lord. Montext, paragraph 40, page 1012.
Thank you.
Now, reverting back to Blomquist, I'm now at paragraph 23, which is on page 978. This is under the heading the questions referred for a preliminary ruling. As a preliminary point, it must be observed that, by its questions, the referring court seeks clarification of the term distribution to the public, that's in relation to the copyright bit, within the meaning of Article 4 of the Copyright Directive, and of the term use in the course of trade within the meaning of Articles 5.1 and 5.3 of the Trademark Directive and Article 9.192 of the Community Trademark Regulation. It's referred to there as the Community Trademark Regulation because this is an old case, and the Community Trademark Regulation then became the EU Trademark Regulation. They keep changing the name, basically. But it's all the same thing. And all those articles, in essence, are all the same, and they're all the same as the UK provisions. In order to assess, in the main proceedings, whether there was any infringement of an intellectual property right. So you can see there that front and centre of the case before the Court of Justice in Blomquist was the issue of what does the term use in the course of trade within the Trademark Directive mean. Paragraph 25, to which your attention has already been drawn, which is the customs regulation introduces no new criteria for the purposes of ascertaining the existence of an infringement of the IPRs. See to that effect Montex. And if you then go to paragraph 30, the reason why this is relevant is that there's been a question of where the sale took place. And there's two answers to that. The first answer we say is contained in paragraph 30, which is, if you look at the end, it says, it therefore remains to be ascertained in order to reply to the questions referred, whether a holder of intellectual property rights, such as Rolex, may claim the same protection for its rights where, as in the case in the main proceedings, the goods at issue were sold from an online sales website in a non-member country on whose territory that protection is not available. Now, in my submission, that clearly points to the fact that the sale occurred in a non-member country where the local protection for Rolex and its trademarks was not available. Well, not applicable. But the other way of looking at it is a more general way, and that is when we eventually get to the dispositif in paragraph 35, it doesn't put down a caveat which says that we would reach different answers depending upon where the sale occurred. And so therefore, in my submission, my secondary argument on this point is that it doesn't matter where the sale occurred. It doesn't matter where title transferred.
But you just told us that for the trademark regulation, it does have to be in the jurisdiction, the sale.
No.
Well,
My Lord, the wrongful act has to be within the jurisdiction. And I'm going to come to the wrongful act that occurred within Blomquist. See, the reason why this is relevant is if the sale had occurred within Denmark, there'd be no need to refer this matter to the Court of Justice because it'd be so obvious. They would, well, first the court wouldn't refer it because it would be obvious, but even if it were referred, the Court of Justice would reply with a reasoned order, which is, the question is so obvious, we don't need to give you a judgment. This is the reasoned order. But they have actually given you a judgment. Therefore, we say that it can't, that factual matrix, i.e. the supposed factual matrix that it's sold within Denmark, cannot be the factual matrix.
what is the infringing Act.
Might I come to that, but in a moment. I need to lay just another small foundation stone. Right. It's paragraph 34, which I need to get to before I come to the dispositif. It is common ground that, in the case in the main proceedings, the goods at issue were the subject of a sale to a customer in the EU, such a situation not being therefore in any event comparable to that of goods on offer in an online marketplace. So therefore this case is different from offering of goods, nor that of goods brought into the customs territory of the EU under a suspensive procedure. So it's different from the suspensive procedure cases.
Oh, just remind me, what is the suspensive procedure?
That's basically when, that's the Philips case, in short.
Yes.
It's actually Philips and Nokia. There were two.
Oh, in transit?
Yes. What happens is you're going between countries X and Y, and you're in transit within the EU, for example. Question is, can you then seize them? And once you seize them, can you then destroy them?
Yeah.
And the point there is, certainly in the Nokia part of the Philips case, the cases, I think, were going from Hong Kong, the phones were going from Hong Kong to Colombia. In neither jurisdiction did Nokia have the relevant rights, but they had relevant rights within. They were seized in London. They were seized in London, yes, where Nokia had relevant rights. And the question then was whether the customs had seized them properly. Does that answer your question, my Lord Briggs?
Yes,
Yeah.
thank you.
Anyway, the point being here, and that's why I went to 34, is that it's neither of those cases here. It's not a suspensive procedure case, and it's not a offering of goods case. Okay? And now I come to answer my Lord Hamblin's question, what is the wrongful act? And that's contained within the dispositif in paragraph 35 on page 980. In the light of the foregoing, the answer to the questions referred is that the customs regulation must be interpreted as meaning that the holder of an IP right over goods sold to a person residing in the territory of a member state through an online sales website in a non-member state enjoys the protection afforded to that holder by the regulation at the time when those goods enter the territory of that member state merely by virtue of the acquisition of those goods. So, in this case, this is a composite act. And so therefore it's an act that is not expressly detailed, remember, in Article 9.3, because that was a non-exhaustive list. And this is a composite act that amounts to use within the jurisdiction. It has three components: a sale to a person residing in the member state, and then that is crystallized at the time when those goods enter the territory of the member state.
Sorry, what's crystallized?
The composite three-part act. So if I have merely a sale overseas, that's not enough. If I have merely a sale to a person resident in the EU, that's not enough. It's a three-part act, and the third part of which is afforded to that holder by the regulation at the time when those goods enter the territory of that member state merely by virtue of the acquisition of those goods. That's the.
I suppose you could summarise it as a sort of cross-border sale, in the sense that it's a sale from one place, that's the website in the non-member state, to a purchaser resident in
The EU.
let's call it the EU. And it's cross-border because between the from and the to, it crosses a border.
Into the EU.
Yes. Sale into the EU.
Yes.
Yes.
And the point is that with that composite three-part act, you have firmly tied the transaction to the EU. There's no long-arm jurisdiction here at all. it is only when you complete all three parts of that composite act, the final part of which is the acquisition of those goods within the EU, that you...
Are we to assume from this dispositif that the purchaser doesn't gain possession of the goods until he or she receives them in the EU?
My Lord, I think the answer to that question is yes.
I think it would have to be.
Yes, because
otherwise you wouldn't have the third element
Yes.
of the goods coming in the course of trade.
Yes, exactly. I was just wondering, sorry, whether your Lord was thinking that they took possession of them abroad and then brought them in.
Yes.
That doesn't work.
No.
For two reasons. One, the person is not acting in the course of trade. Let's assume that they're not smuggling Rolexes for selling on. It's just for their personal use. And secondly, because of Article 3.2 of the Customs Regulation says the Customs Regulation expressly does not bite in those circumstances so long as it's in their personal luggage. This is the point about bringing it in.
Yes. Well, I assumed that was the case. It was just within the wording of the dispositif itself.
Yes. Yeah.
One has to read in restrictions.
Yes, it's a three-part composite act.
All done by the trader.
Yes.
Yes.
Because, and it must be the trader, because that's the only party that's acting in the course of trade. And the point to which I referred you earlier is that this was all on the assumption that Mr. Blomqvist was not acting in the course of trade. He was acting in a personal capacity.
So you could say that the three components: one, sale by the trader to a person residing in the member state, and the goods enter into the member state through the act of the trader or its agent.
Yes, my lord.
Yes.
And you would presumably also say that it doesn't, within providing those conditions are satisfied, matter quite where or when title passes.
Yes, exactly, my lord. Sorry, my learning friend was about to say something. Didn't want to say something without his learning. See, that's the point, you see, is that there is no long-arm jurisdiction. No liability arises until you've finally cemented that composite three-part act to the jurisdiction. So,
and is the sale part an infringement?
No.
Well, if it's a sale for delivery within a member state, it might be. I'm just imagined that the goods were on a ship that sank on the way. Would there have been an infringement at the time of the sale? I think your submissions lead to a conclusion that there's a sufficient tethering of the sale to the EU because it's a sale for delivery in the EU.
Yes, yes. I mean, the thing is, though, the whole thing wouldn't have been completed, so it might be a threatened...
Sure. And the customs wouldn't be involved, that's for sure.
Yeah, it'd be a threatened composite act in those circumstances because it wouldn't have been finally completed. But all the intentions were there.
Mm-hmm. We get the same from paragraph 29.
29?
Paragraph 29, on page 979 of the bundle.
One with distribution to the public.
Yes. Yes.
The sale be considered as a form of distribution to the public and use in the course of trade within the meaning of the Trademark Directive or the Community Trademark Regulation. And that is proven when a contract of sale and dispatch has been concluded.
Yeah, so you've got this. The point about 29, though, is it doesn't tie it so clearly expressly to the EU because it doesn't talk about the sale to a person resident within the EU and the delivery to the EU. So,
well, I think it's implicit.
It's implicit, but it doesn't say it expressly.
I see.
Yeah. And the dispositif, of course, is the thing that you take from a Court of Justice case, interpreted in the light of its reasoning. So
the telephone example that we were talking about before, you say is satisfied by these criteria?
Sorry, which telephone example? Because there's a Nokia telephone example and...
Oh, sorry. The purchase of the goods from the United States by telephone
Oh, right, that telephone style.
Sorry. I think it was Lord Kitchen's example.
Yeah.
And then sent to the UK.
Yes.
Providing it's in relation to the relevant goods.
The mark.
And in relation to the relevant territory, that it's coming into
Yes, my lord.
the EU, and
Yes.
it's the mark applied to those goods,
Yes, my lord.
protected by the mark.
Yeah. I'm sorry, my Lord Barrels, I got confused with whether you're referring to the Nokia telephone case or what. That then brings me to the points raised by my learned friend on this. I'm just going through my notes. Oh, yes. Yes, thank you. It's sometimes said that Blomquist is an outlier because not many people rely upon it. And two of the cases that rely upon it are Cartier and Walton. And those are both cases ruled upon by Mr. Justice Arnold, as he then was. So one could say that's a little bit of a circular bootstrap argument. But there's a little bit more than that, he says, thankfully. And if I go to L'Oreal, oops, Daisy. Yeah. And it's L'Oreal, paragraph 67, and it's page 952. Now, it's true L'Oreal was a different sort of case, but in 67, it does provide express support for this proposition because it does say it's in answer to the seventh question referred is that where goods located in a third state which bear a trademark registered in a member state of the EU or a community trademark and have not previously been put on the market in the EEA or in the case of a community trademark the EU, little Roman 1, are sold by an economic operator through an online marketplace without the consent of the trademark proprietor to a consumer located in the territory covered by the trademark. So that's the Blomquist case, basically, as identified in paragraph 29 of Blomquist and as elaborated in paragraph 35 of the dispositif in Blomquist. And then it says, or, little Roman 2, are offered for sale or advertised on such a marketplace targeted at consumers located in that territory. So this clearly draws a distinction between little Roman 1, which is the sale to a person within the EU, where no mention of targeting is made, or little Roman 2, where there's an offer for sale or advertisement and you require targeting. And you see, again, with respect to the facts of Blomquist, it's a sort of yes-no type of question. Is there a sale to a person within the EU that has been consummated by delivery? Those are yes-no type points. Now,
can you just remind me, is Cartier, is L'Oreal before Blomquist?
yes. L'Oreal is quite early on. It's the decision was in it's reported 2011.
Yeah.
It doesn't actually give the date of the, but it's yes, it's 9th of December 2010. Oh no, that's the AG. The decision was 2011 itself,
Yeah.
July 2011. You get that from page 893.
Yes, thank you.
Yeah. There's a little bit of other support. The first of which is from Curley. This is Curley's Law of Trademarks and Trade Names, which is, as some of you will know, the leading book on trademark law. You'll find that starting at page 1053.
When was the last edition of Curly?
I was fearful you were going to ask me that. I'm sorry. We've got the 16th here, but I'm not sure that is the last edition.
A little while ago, I think.
Yes. Trouble is, I now just use the online version, and I don't have it sticking out on my desk. I can find that out, my lord.
The online version is that updated beyond the supplement?
Not beyond the supplement.
And what is the date of the supplement?
I'll find that out. Sorry, my lord.
And this bears the imprimatur of Mr. Alexander's predecessor, Mr. Miller.
My lord, yes, but I wasn't going to either hold that for or against anybody.
I suspect Curly just records what the extracts from the judgment, doesn't it? From L'Oreal and,
the answer to that is yes, my lord. It does so twice, but it does so without saying that they're good or bad. So
bold statement by the editor to say that the reasoning of the Court of Justice was...
my lord, this might be polemic, but I've never felt that the authors of Curly have held back. I mean,
well,
they treat it as a case of import. They treat it as a case of import.
Yeah.
They say it's got to be determined precisely who's responsible for the importation.
Yeah. And in this case, it would be the overseas person. Yeah. So you see there's two references, 16.023 and then 28.078. And the second one is the liability of internet service providers. They're worded very slightly differently, but nothing material. And then there's another textbook which you'll find starting on page 1056, which is Kerr's European Trademark Law, a commentary. And it's on page 1058 of your bundle, which is actually the penultimate page. And it's paragraph 547. As the sale to Mr. Blomquist had already been concluded, the mere fact that the sale had been made from an online sales website in a non-member state could not deprive Rolex of the protection afforded in the EU without it being necessary to verify whether such goods were prior to that sale the subject of an offer for sale or advertising targeting the EU customers. The CJEU emphasised that given the sale, the requirements for invoking protection differed from a mere offer in an online marketplace requiring a website targeting, or the case of goods in transit, which require a commercial act directed to EU consumers. That's a reference to Philips. Should be a reference to Philips.
Have there been case commentaries on Blomqvist?
This is what we found, my lord. So the answer is there may be, but we haven't found them. My learned junior, my Lord Kitchen, the 16th edition is 2018 and the supplement is 2021.
Thank you.
So, my Lord, that's how I was going to address you on Blomqvist. I realise I finished very slightly early, but...
if you're happy that you've got plenty of time to cover the...
We're supposed to have 2 hours tomorrow, my Lord.
Yes, if that's ample for your coverage of point 2, then I'm perfectly content to
my Lord,
adjourn at this stage, if you so wish.
My Lord, I'm happy to accede. Yes.
We'll adjourn now, then. Thank you very much indeed.